But one of the cases that came out in one of the briefs that we use to this day came from Don Turner, in which he wrote a scathing indictment on the Supreme Court's decisions in Williams versus Florida. And this case came down 5-4. In the back of this case are 4, in part concurring and dissenting opinions. This fellow Williams, to give you a little background, is a criminal, and he goes out and he robs and rapes and pillages, and he does this in Florida. And in Florida, as in many states, they have provision in their state constitution for a 6-man jury. Now, as we've already seen, the very word jury means, at common law, means 12. So now we're going to have a 6-man jury, which is ridiculous on its face. If the word jury means 12, then you can't have a jury of 80. You can have a tribunal of 80 and a tribunal of 6, but you can't have a jury of 6 or a jury of 80. And that's not what the essential issue of this case is. The essential issue of the case is due process of law under the 14th Amendment, because what this man asked was, now here he's convicted of his crime, whether he raised this as a question prior to trial, I'm unable to determine. I don't know. I don't know whether he raised the issue timely. All I know is that he raised the issue of the jury among 2 or 3 other issues, and the question raised was, does a common law, no, he didn't ask the right question. That would be the right question. What he asked was, does a 6-person jury deprive me of my right to due process under the 14th Amendment? And the answer to that, the court said, was no. And then they went on to go through the jury issue. And there's a lot said in here concerning the jury issue, and it has been our contention here at the school for a long time, and of course Don Turner said there is total confusion out of this case, and I agree, there is some confusion out of this case, but I think if we read it, we may be able to make some sense out of it. My theory of this case is this: the Supreme Court did not want to turn this man loose. And at the same time, the Supreme Court did not want to meddle in the constitutional requisites or prerequisites of the state of Florida in passing a constitutional amendment which required the people to pass in providing 6-person juries. I think the correct question would have been, is it proper or can a state convict a man in a felony case with less than a 12-man jury at the common law? A common law jury is a 12-man jury. I'm convinced of that. A civil law jury can be any number of people, of which this court said, we have no occasion in this case to determine what minimum number can still constitute a jury, but we do not doubt that 6 is above that minimum. That's on page 78, down at the very bottom of the page in the footnote. Now, in this state of Florida, they're trying this man, evidently, under a civil statute. They have codified their statutes. They have made common law crimes, statutory crimes, converted those crimes then to the civil law. And under the civil law, I have no doubt but what those people can try a defendant in a court with 6 people, and they're saying here in the Supreme Court, we don't know what minimum number is necessary, but we're sure that 6 is above that minimum. Now, looking at this entire footnote, listen to these words. The Thompson opinion also reasoned that if a jury can be reduced from 12 to 8, then there was nothing to prevent it similarly being reduced to 4 or 2 or even 0, thus dispensing with the jury altogether. See 170 U.S. at 353. That bit of logic, resurrected today in Mr. Justice Harlan's concurring opinion, suffers somewhat as soon as one recognizes that he can get off the slippery slope before he reaches the bottom. You can get off the slippery slope before you get to the bottom. How would I get off of that slippery slope? by demanding a common law trial. I think that's what they're talking about in this case. I think that the court is saying, had you demanded a common law trial and all of your rights at the common law and demanded a common law jury and a common law trial, I think then you'd have had to have a 12-man jury. Now let's go up to the front of this case, the very beginning here, and let's get a little background and beginning. Because Don Turner was apparently totally confused by this distinction, or this, not distinction, let's use the word reversal of the Supreme Court's decisions in the Thompson case. But we've already determined that there is a broad gulf between the civil law and the common law, and that Americans en masse have turned totally to the civil law and totally against the common law until our common law no longer functions in the United States, and it can't function because there's no substance, and because we've now codified our common law. In other words, if you had a robbery, you didn't need a statute that said thou shalt not steal. Hell, everybody knew it was against the law to steal. All you needed was an information by a farmer who went to the grand jury and said, my neighbor, Joe Baloney, broke the fence down and stole my prize bull. You didn't need a statute that said, well, you've got to brand your bull and you've got to have a code or a statute that says it's against the law and there's a punishment and a penalty. You have to have statutes to regulate corporate entities, but you don't need statutes at the common law to regulate your conduct and mine. All we need is a loss of life, liberty, or property. And when you stole my bull, there's a loss of property. And that's a crime at the common law. We'll go to the grand jury, and the grand jury will decide whether or not that's a crime, or whether it's a civil issue. The neighbor will come into the grand jury and we'll talk about it. Now, we're not talking about a grand jury in this case of Williams. Williams was prosecuted by information, evidently. And he goes in here on a civil statute. And under the civil law, a civil statute, he doesn't need any common law jury. He demanded a 12-man jury, but I think the thing that he left out was the demand for a common law trial. Now, let's see whether or not my theory will be substantiated when you get your case to the Supreme Court of the United States. I think that is the crucial distinction in this particular case, that he asked the wrong question, and he got the right answer to his wrong question, because White said there's a way to get off the slippery slope. And if there was no way to get off the slippery slope, then they would have had to have addressed that 12-man issue pursuant to the common law. They use the common law terms in here, and they're talking about common law, and they talk about the Thompson case, but yet their ruling appears to be totally against the common law and totally against the 12-man jury. I think there's a way off the slippery slope. Let's run through this and let's see if that's true. Florida has a rule. Let's start up here on page 78. This is 399 U.S. 78, decided in the October term of 1969. Florida has a rule of criminal procedure requiring a defendant who intends to rely on an alibi to disclose to the prosecution the names of his alibi witnesses. So one of the issues here is the alibi issue here in Florida. And then going on, down here at the bottom of the page, he goes on and says, the constitutional guarantee of a trial by jury does not require that the jury membership be fixed at 12. A historically accidental figure. What? A historically accidental figure? Although accepted at common law, the framers did not explicitly intend to forever codify. Do you see the word codify as a constitutional requirement, a feature not essential to the Sixth Amendment's purpose of interposing between the defendant and the prosecution the common sense judgment of his peers? We have a code that this fellow Williams is being prosecuted under. You see that? We have the civil law. Mr. Williams isn't being prosecuted at the common law. He's being prosecuted under the civil law. Under the civil law, Mr. Williams doesn't need a jury at all. All this is a traffic ticket. This guy ran out and robbed a Circle K store, and the policeman gave him a ticket and hauled him off to jail, they're prosecuting him just like they would as if he were speeding. Nothing more, nothing less. This isn't a common law trial. At least that's the way I see it. Now let's go on here. I've underlined a few of the more pertinent sections as I went through this case, trying to find out whether or not our Supreme Court has in fact nullified and done away with our common law. I don't believe that for a minute, and I think a lot of us patriots have gotten it in our minds here that this commie pinko Supreme Court has been ruling against us, and some of us haven't had a total or a clear understanding of this distinction of the common law and the civil law and how it applies. And I think here's where Walt Mann has separated the men from the boys, because you see, you have the administrative procedures under the civil law. And once you have given up your common law status and volunteered by contract in some capacity into the civil law, well, what do you need a jury for? You go out to the traffic court. You got a driver's license in your pocket. There's the evidence of your voluntary consent into a regulated enterprise. Now, I'll concede I don't understand how Mr. Williams got his voluntary acquiescence into a regulated enterprise, but somehow or another, Mr. Justice White said you can get off the slippery slope, and that's a term that the Supreme Court has used for many, many years in designating this difference between civil and common law. Wait a minute, we're on the slippery slope. No, you can get off. Oh, well, if I can get off, then there's got to be a way. Now, the Supreme Court, remember, pursuant to the 7 rules of deciding cases, is not going to give you the answer. All they're going to do is say yes or no. They could have, said, wait a minute, Williams, in this case, is prosecuted under the civil law, and had he demanded a common law trial, then we would have said, yeah, a common law jury is 12, because they admit that. White goes through this case and keeps saying over and over again, well, certainly a common law jury is 12. And yeah, and here's the way it got started and all this and that and another thing. But when they get to the end of it, judgment affirmed. That's right, judgment affirmed. The guy asked the wrong question. Going on then at the bottom of page 78. Petitioner also filed a pretrial motion to impanel a 12-man jury instead of the 6-man jury provided by Florida law in all but capital cases. That motion, too, was denied, and the petitioner was convicted as charged and was sentenced to life imprisonment. The District Court of Appeal affirmed, rejecting the petitioner's claims that his 5th and 6th Amendment rights had been violated. Well, of course his 5th and 6th Amendment rights could not have been violated at the civil law. Under the civil law, he had a contract or he had some kind of voluntary acquiescence into this jurisdiction. Did he challenge the jurisdiction? I don't know. Did he demand a common law trial with a common law jury? I don't know, and I don't think so. I think he volunteered into the civil law jurisdiction. The civil law prescribes a 6-man jury. He was convicted and sentenced, and I don't see a problem with it. If that theory is correct, if our conclusions here at the school are correct, and there are 3 of us now who have gone through this, and I'm not saying by any stretch of the imagination that we're the greatest scholars on law, but I think that reason, logic, and common sense comes into play, and I think that if we use that theory, then the Supreme Court ruled correctly, the Florida State Constitution is correct, and that the simple difference is that you've got the civil law on one hand, of which Williams was a member, and he was subject to the civil law, and a 6-man jury was fine, because he did not demand a common law trial. He evidently was not a sovereign citizen under the common law. When we go into the traffic courts, we claim our rights as sovereign citizens under the common law and demand a common law trial. And that's a common law jury, not a civil law jury. Now, nowhere in this case can I see that Williams made that distinction and made that demand. And I think the Supreme Court simply said, well, I don't see any evidence in here that Williams is a sovereign. I don't see any evidence in here that Williams doesn't have a contract with the state, so therefore the civil law prevails. All right. Going on, let's read some of these key underlined statements in this Williams case and see whether or not I can be vindicated or whether or not my position can be upheld. Here's a footnote on page 87. At the bottom of the page, at the beginning of the 13th century, 12 was indeed the usual, but not the invariable number. But by the middle of the 14th century, the requirement of 12 had probably become definitely fixed. Indeed, this number finally came to be regarded with something like superstitious reverence. A. Scott, Fundamentals of Procedure in Actions at Law. Footnotes omitted. Actions at law are common law. And so, here's your Justice White going through the Williams case and saying, well, it looks like at the common law, 12 became fixed. At the bottom of page 88, footnotes again, this number is no less esteemed by our own law than by Holy Writ. If the 12 apostles on their 12 thrones must try us in their eternal state, good reason has the law to appoint the number 12 to try us in our temporal. The tribes of Israel were 12, the patriarchs were 12, and Solomon's officers were 12. Trial by jury, 1877, quoting G. Duncombe in Trial per Pi. Okay, so here's facts coming out. Here's your 12-man jury, and here's the justice writing the case, and he's not sitting here denying that 12 is not a proper number for a common law jury. He does say some words here. Let me read this little section to you. It's kind of marked out here. Starting on page 88, at the top it says, other less circular but more fanciful reasons for the number 12 have been given, but they were all brought forward after the number was fixed, and rest on little more than mystical or superstitious insights into the significance of 12. Lord Coke's explanation that the number of 12 is much respected in Holy Writ as 12 apostles, 12 stones, 12 tribes is typical. In short, while sometime in the 14th century the size of the jury at common law came to be fixed generally at 12, that particular feature of the jury system appears to have been a historical accident unrelated to the great purposes which gave rise to the jury in the first place. The question before us is whether this accidental feature of the jury has been immutably codified into our Constitution. Now, the Constitution makes provision for both the civil and the common law. So the question here then is, in White's mind, as I'm trying to read White's mind as he's reading this, because I think a lot of the time we have a hard time looking objectively here at facts. We say, this White's doing away with our Constitution, and he's anti-scriptural, and he's ungodly, and he's a pagan, and he's this or that, because we're on this side, or on the other side we say, yay for White, we wanted to do away with these superstitious 12-man juries, these superstitious 12 apostles, and this entering into our judicial system. So you have both sides at loggerheads with one another. And here's White coming along, and he's writing the opinion, and he has knowledge of the civil and the common law, and so he's just sitting here with his neutral hat on, writing an opinion. So far he hasn't said that the common law jury doesn't consist of 12. He says, yeah, that's right. Common law jury consists of 12. And he hasn't said a word here to nullify that fact of history. This Court's earlier decisions have assumed an affirmative answer to this question. The leading case so construing the Sixth Amendment is Thompson v. Utah, 170 U.S. 343. So he goes back to the Thompson case. And he goes on to say that there the defendant had been tried and convicted by a 12-man jury for a crime committed in the territory of Utah. A new trial was granted, but by the time Utah had been admitted as a state, the defendant's new trial proceeded under Utah's Constitution, and so on down the line. And actually, the Thompson case is an ex post facto case. It's not a jury case anyway, and the jury issue out of Thompson is dicta. It's an aside. It's not the essential quotant in the case. Going on to page 78, page 91, subsequent decisions have reaffirmed the announcement in Thompson, often in dictum, and usually by relying, where there was any discussion of the issue at all, solely on the fact that the common law jury consisted of 12. And he goes on to say, see Patton versus U.S. and so on down the line. The footnote down here says, while much of our discussion in this case may be thought to bear equally on the interpretation of the Seventh Amendment's jury trial provisions, we emphasize that the question is not before us. You see, the question isn't before us under the Seventh Amendment. We do not decide whether, for example, additional references to the common law that occur in the Seventh Amendment might support a different interpretation. Do you see these clues that are coming on now? Common law juries are 12. Historically, they're 12. We can get off of the slippery slope. The Seventh Amendment refers to a common law jury. And he says we're not asked to make that determination in this case. Now go back to the 7 rules. If we don't have to answer the question, then we're not going to address it. And I don't think the Williams case addresses a common law jury or the number of persons that it takes to set on a common law jury. I'll concede that because the court did not go further and sit down, Now here's what White should have said. He should have sat there and said, look, fellas, let me explain this. The Constitution is set up and recognizes the civil law and the common law. Nowhere in the Constitution is the number 12 cast in cement. Therefore, the question of a 12-man jury, insofar as the Constitution and the 14th Amendment are concerned, can be decided this way. There's no reason why you have to have a 12-man jury. Because, you see, Williams is being tried under a statute, not under the common law. If Williams had asked the question or demanded a common law jury, can I be denied a common law jury of 12 in a common law trial, I think White would have said no. I don't think so. But that isn't the question White's deciding here. It's the number 12 pursuant to the 14th Amendment, and did it deny Mr. Thompson his right to due process? Your right in a traffic court to due process isn't denied with a 6-man jury. Why should your right to due process for a murder be decided by a 12-man jury under the civil law? The civil law doesn't guarantee you a 12-man jury. We don't know what the minimum number is, but we are sure that 6 is enough, said White. Now, do you begin to see what White is doing? He is craftily wording this case in such a way that he does not have to tip his hand. He's a careful poker player. He's simply saying in the case as he goes through, I'm going to talk about the common law, but I'm going to craftily avoid telling you what I'm really thinking. I'm just exactly answering the question that you raised. Am I denied due process under the 14th Amendment to the Constitution and the 5th and 6th Amendments by not having a 12-man jury? And the answer is no. Now let's go to lunch. See what he's done? He has never addressed the issue of the Thompson 12-man jury, the 12 apostles, the history of the common law jury. I've read to you in the first half of this tape dozens of cases, and when you take this book, I'm telling you literally hundreds of cases. The very definition of the word jury means 12. But not in the civil law. Not by the terms of the ancient Phoenicians. Not by the terms of Roman mercantile equity, it doesn't. And the civil law is as much a part of our Constitution as is the common law. I mean, after all, admiralty comes under the 3rd article. I didn't write it. It's there. I don't know if it's good or bad or right or wrong. Maybe all admiralty should be thrown away and buried in Davy Jones' locker. All I know is that when we're talking about our Constitution, we're talking about, on the one hand, we've got our common law on land, and we've got our admiralty law at the high water mark. And these international banksters have now grafted that admiralty jurisdiction on our rivers of tar. They have given us, they have sold us, or we've sold ourselves. I don't know how it occurred. All I know is that we're now engaged in mercantile equity. We're engaged in admiralty contracts. We're engaged in rivers of tar. We drive our vessels up and down these rivers of tar, and we volunteered into these jurisdictions. And somehow or another, in this Williams case, I don't know how you volunteer into mercantile equity under a codified code. Now that we don't have figured out. But I know this, that evidently you can do that, and evidently Williams didn't object to it. He asked the question under the Fifth and Sixth Amendments, can I be tried with less than 12 men? And White is saying, yeah, you can. Because the Florida Constitution says 6 is the number. But once the codes were passed, once you codified robbery, now you're in the civil law. But can the civil law be compelled or enforced upon a sovereign citizen and an individual? And I contend that the answer to that is no, because of the Hale Doctrine. There's a clear distinction between corporate capacity and an individual and a sovereign citizen. Your rights under the Constitution have to be claimed. And if your status is screwed up, then when you go into the courtroom, you're in the civil law, not in the common law. And I think that's the explanation here in this Williams case. Why don't you go ahead and read the Williams case and see if your brain works any differently than mine? I think with that explanation, it's either I'm right in this position or the Supreme Court did in fact reverse our ancient common law traditions of the 12-man jury. If in fact that occurred, then we have a total renvoy. We have one case in 1970 with the Williams decision that has just nullified 600 years of our history, our Constitution, and of our processes in the courtrooms, and literally hundreds of cases, of which Thompson is only one. And in the stroke of a pen, the Supreme Court has simply said, to hell with the Constitution and to hell with our 12-man jury. That was the conclusion that Don Turner came up with over in Denver, and I contend that Mr. Turner, with all due respect, does err not understanding the Supreme Court's determination in this case. I think that the court was not asked to make that determination. They did make a determination, and they did make a way to get off the slippery slope. I think that the wrong question was asked and the right answer was given to that wrong question. And total confusion has now reigned over the United States from this decision on. Now let me illustrate this with one more example, and then we'll go on to the next issue. Out in Illinois right now there is a case going on a concealed weapon. No, it wasn't even concealed weapon. I think it was Morton Grove, Illinois. If that's not the name of the town, well then you've probably read about it and you can correct it. In any event, this little community has passed gun control legislation. They have claimed under their police powers the power to shut down any of the sporting goods stores in town and told all of its people that they cannot own guns. And they claim the police powers for doing that. All right, so there's the issue. Somebody there who is a lawyer has taken the case to court, and he's been defeated 2 or 3 times, and I think now he's moving it up to the Illinois Supreme Court. He's claiming that the law is unconstitutional and it's in violation of certain constitutional rights. And I'm going to predict for you today the outcome of that case. The man's going to lose, and we're going to have some more bad decision, because either the Supreme Court of the United States is not going to grant certiorari, is not going to listen to the case, in which case the state Supreme Court, who's going to, I predict, rule that Morton Grove has the power to make such an ordinance. And then watch the headlines nationwide. Gun control ordinance upheld. And then watch how the police enforce gun control. Wrong person, wrong question. What he should have done, remember, pursuant to the 7 rules that you got in Lesson 13, he had to have been damaged by the action of the ordinance or the statute. He should have strapped a gun on, walked down the street, met the police chief and said, "See the gun, dummy, what are you going to do about it?" Then if the police chief would have arrested him and thrown him in jail, he would have been damaged constitutionally by the workings of the ordinance. Now he would have had a constitutional issue with which to work its way on up through the courts to the Supreme Court, and my prediction would be then that the Supreme Court would say he's got a right to wear the gun, butt out. But that city can license and regulate its sporting goods stores, and the fellow hasn't been damaged by the workings of the ordinance at all. And where there is no issue, where there is no cause, the court will not rule. They'll not even listen to it. And if they do, remember, one of the rules is, if we do, which is very seldom, then we're going to construe the statute, if it's at all possible, as being constitutional. And what is unconstitutional or illegal or unlawful about the city using its police powers to regulate one of its licensed businesses? Remember, in the driver's license cases, such as Smith and Thompson in Virginia, the state can regulate and license anybody who's using a taxi cab on the public roads. There's no problem with that. And so do you see what's going to happen in that Morton Grove case? That's what happened with the jury issue. We had a dumb criminal down in Florida confuse the civil law and the common law, asked the wrong question, and the court gave him the right answer to the wrong question, and now we have nothing but total confusion because the lawyers who have been to law school and trained in the civil law now construe this to mean that a 12-man jury has now been done away with, and that the Supreme Court, with its blessing, will just do away with 600 years of our tradition and our common law and our jurisprudence with the stroke of a pen with one case. You can do away with hundreds of cases with one case, with one dumb criminal. And I don't think that the Supreme Court of the United States meant to do any such thing, and I don't believe they did that in this Williams case. And so I invite you to read this along with these dissenting opinions, and then why don't you write to me and see whether or not our opinion here at the school coincides with the opinion that you come up with based upon what we've just outlined with this Williams case and in these jury cases up to this